So imagine a police officer standing on the front porch of a house.
Okay.
Right? They have a lawfully signed warrant from a judge. They have hard evidence of a serious crime. And, backup is ready to go.
Yeah.
But when they try to turn the doorknob, they realize the door literally doesn't exist in the physical realm.
Yeah, that's a pretty wild scenario.
Right. Because the company that built the house, well, they mathematically destroyed the keys the exact moment the house was constructed. And no amount of legal authority can force that door to just materialize out of thin air.
Exactly. And honestly, that scenario is exactly why we're here today. Welcome to the Deep Dive.
Yes, welcome. Today we are jumping into a really fascinating stack of legal analysis and technical notes from the Ambat Legal Insight team. And the mission today is to examine a question that affects every single person listening right now, which is, can a government actually ban end-to-end encryption?
Right. And we are looking at a collision here between the fundamental laws of mathematics and the jurisdictional power of the modern state. I mean, this is not just some niche IT dispute.
Oh, definitely not.
It is an active, massive constitutional tug of war. We're talking cybersecurity, free speech, national security, and really the mechanics of digital democracy itself. Every time you open WhatsApp or Signal or iMessage, you are right in the middle of this debate. You're participating in a system that fundamentally challenges how governments have historically exercised power.
Okay, let's unpack this, because your phone isn't just a communication device anymore, is it? It's basically a digital fortress.
It really is.
But the big question the Ambat team asks is, who actually holds the keys to the gate of that fortress?
Well, to understand this whole legal battle, we really have to wrap our heads around the architecture of that fortress first.
Right, the anatomy of a locked box. Now, I know most of you listening are probably familiar with the basic premise of end-to-end encryption, or E2E.
Yeah, we aren't going to patronize anyone with the old, it's a lockbox in the mail analogy.
Though it is a classic for a reason, like sending a letter inside a locked box where only you and your friend have the keys, and the Postal Service, which is the app, just delivers the box.
Right, but looking at the technical breakdowns provided in the legal analysis, it is crucial to understand the actual mechanism of how this works. Because that mechanism, the math, is what is driving the entire legal panic.
So walk us through that mechanism. Where exactly do these keys live?
The mechanism is entirely about where the cryptographic keys are located. So in traditional encrypted systems, think of the early web or standard cloud storage, your data is encrypted while it travels from your computer to the company's servers.
Okay, so in transit.
Exactly. But the company holds the keys. They decrypt it on their end, store it, and they can read it. Or, crucially, hand it over to authorities if they're compelled by law.
Which happens all the time.
Right. But end-to-end encryption flips that entire architecture. The cryptographic keys, specifically the private keys used to decrypt a message, are generated locally. They live purely on the physical silicon of your smartphone or your laptop.
Wait, let me just pause you there. So even the messaging company itself cannot read the texts. That seems totally counterintuitive to the usual tech business model, right?
Yeah.
Where they harvest all our data for ads. It really is a blind delivery service.
It is a blind delivery service.
Right.
They never traverse the network. The server never sees the keys. The messaging company only handles ciphertext, which is just a mathematical scramble of data. So when law enforcement serves a subpoena to a tech giant demanding the contents of a suspect's messages, the company isn't being stubborn or obstructionist when they say no.
They literally can't do it.
They mathematically cannot comply. They are holding a locked safe, and they fundamentally do not possess the combination.
Which brings up a fascinating irony in the geopolitical landscape, right?
Right.
Because the Ambat Legal Insight analysis highlights the sheer scale of what relies on this exact mathematical architecture.
Yeah.
We were talking global financial markets, hospital databases.
Medical records, legal advice, digital payments.
Right. Intellectual property transfers, power grid communications. All of it depends on the fact that these private keys cannot be intercepted.
And here is the absolute fiercest irony of the whole thing. Do you know who the biggest advocates for strong encryption are?
Let me guess. The government.
Exactly. The intelligence agencies and militaries of the very governments currently trying to regulate it.
That is wild. They use the exact same encryption to protect their own classified information.
Yeah, they use the exact same AES 256 standards or similar protocols to protect state secrets. They demand absolute, unbreakable encryption for their own communications, knowing full well that a backdoor for one is a backdoor for all.
Yet they are pushing legislation to force tech companies to weaken those exact same protocols for the general public.
The contradiction is glaring, I know. But, we have to look objectively at what is driving the law enforcement perspective here, because they have a valid point.
Right, and this is known in the sources as the going dark dilemma.
Exactly, going dark. Historically, if the state had sufficient cause and judicial oversight, it could intercept the communications of bad actors. Wiretaps were physical things on telephone poles. Today, that capability is just evaporating.
I want to push hard on this point for a second, because I think it's really easy to get lost in the abstract theory of privacy and sort of ignore the very grim reality of what this going dark dilemma actually entails.
It's a very dark reality.
The Ambat analysis lays out the specifics clearly. We are not talking about white-collar tax evasion here. Bad actors use the same tools as good citizens. We are talking about highly coordinated drug cartels, international terrorism, and vast child exploitation networks.
Right. These syndicates use the exact same publicly available open source encryption protocols as human rights activists. They operate with total mathematically guaranteed impunity.
So go back to my analogy from the intro. It's like a police officer showing up with a valid search warrant for a house, but the house has literally been phased out of reality. The warrant is legally sound, but physically useless.
That is a perfect synthesis of their frustration. Investigators do everything by the book. They track a suspect, they gather physical evidence, they convince a judge that a crime is imminent or has occurred, and they get a perfectly lawful court warrant. They hand it to the messaging company, and the company honestly says, "We can't help you. We don't have the keys." They get a string of alphanumeric garbage.
And from the perspective of a police chief or a federal prosecutor, that is an unacceptable breakdown of the social contract. I mean, a judge's order shouldn't be neutralized by an app update.
Yeah, they argued that legal authority shouldn't be trumped by engineering choices.
Right. If you are a victim of a crime orchestrated via encrypted messaging, saying, well, the math won't let us, that's a pretty hollow excuse.
It is incredibly frustrating for investigators. The tension exists because legal authority does not automatically equal technical capability anymore. For a century, the law assumed that if a warrant was issued, the physical world would comply. A safe could be drilled. A door could be battered down.
A telecom switchboard could be tapped.
Exactly. End-to-end encryption is really the first time in modern history where a perfectly legal, judicially authorized warrant is physically and mathematically impossible to execute.
So if the government has a valid warrant, shouldn't the tech companies just be forced to build a key? Just change the math. The reason they aren't forced to brings us directly to the constitutional shield.
It does. And if breaking the math breaks the internet, how do you handle it legally? India provides a really fascinating watershed case study for this dynamic. We look at the 2017 Supreme Court Puttaswamy judgment.
Oh, right, where they unanimously declared privacy a fundamental right.
Yes, under Article 21 of their Constitution, which guarantees the protection of life and personal liberty. But the way the court defined privacy is what's critical here.
How so?
Well, it moves completely away from the outdated idea that privacy is just about keeping secrets. The whole closing the blinds so your neighbors don't see your messy living room concept.
Right.
The Puttaswamy framework defines privacy as informational self-determination. It is about human dignity, autonomy, personal leader, and the right to control your own information.
It's a prerequisite for everything else. Freedom of expression, freedom of association.
Exactly. Think about journalists protecting a confidential source, lawyers maintaining attorney-client privilege, doctors with patient records, or just citizens discussing politics. None of these exist in a meaningful way if the underlying communication infrastructure is inherently compromised.
But let me interrupt and play devil's advocate for the listener here. If I'm just an ordinary person and I'm not doing anything illegal, why should I care if the government can read my texts? Is this digital dignity really that tangible? Why is my right to vent about my boss more important than catching a cartel?
It is a pervasive argument, the whole "I have nothing to hide" thing. But constitutional lawyers dismantle it by pointing to the mechanics of the chilling effect.
The chilling effect.
Yes. This isn't just a philosophical concept. It is an observable shift in human behavior. When an infrastructure of mass surveillance is built, even if it is intended only for catching the worst criminals, the general population internalizes that surveillance.
The psychological weight of knowing you could be watched.
Exactly. You don't need to be doing anything illegal to change your behavior. If you know every message could theoretically be scanned or stored, the societal dialogue shrinks. People simply stop speaking openly.
They self-censor.
Yes. Marginalized groups, political opposition, whistleblowers, they just stop coordinating. The space for exploring controversial ideas evaporates. You cannot build the infrastructure of a police state and expect a free society to carry on normally inside it.
Okay, so governments find themselves in a massive bind. Because constitutional rights like privacy are so strong, they look for alternative routes, legal loopholes to get what they need without explicitly reading the private messages.
Right, which brings us to Section 69 of India's Information Technology Act, and this incredibly intense debate over something called traceability.
Traceability, let's dig into that, because Section 69 allows the government to intercept information for national security and severe crimes. But since tech companies don't have the keys, the government pivoted.
They did. They basically proposed a rule saying, look, we don't need to read the content of the message. We just need you to tell us the identity of the very first person who sent it.
The originator.
Right. If a viral message is inciting a riot or distributing illicit material, the state wants the platform to trace that specific file back through millions of forwards to find patient 0.
And honestly, on its face, to a layman, that sounds like a totally reasonable compromise. You aren't reading my texts. You're just tracking the origin of a dangerous file.
It sounds great in a press release, but tech companies and cybersecurity experts push back extremely hard. They look at this proposal and see an absolute catastrophe.
Because traceability fundamentally weakens the whole E2E system. Let's visualize this for the listener. So instead of reading the letters, the government is demanding the post office keep a permanent, identifiable list of exactly who bought every single envelope, just in case one is used for a crime later.
That is a brilliant way to put it, because you can't just trace the bad messages, right? You don't know which message is bad until after it has been sent, forwarded, and reported.
Obviously.
Therefore, to ensure you can trace a bad message in the future, you have to permanently attach an identity tag to every single message sent by billions of people.
It destroys the whole concept of the system.
It destroys forward secrecy. In a true system, the session keys are ephemeral. They exist for one exchange and then they vanish. Traceability forces the creation of a massive permanent surveillance database by default.
Which introduces what the Ambat notes call the good guy backdoor fallacy.
Yes, the core technical truth. Politicians often demand a vulnerability that only law enforcement can use. A special secure entrance into the digital fortress for the good guys.
But you cannot create a backdoor only for the good guys.
No, cryptographers have been saying this for decades. A lock with a master key is inherently broken. Think of it like engineering a highly infectious virus that is programmed to only attack bad cancer cells.
The intention is noble, sure.
Very noble. But once that engineered virus is released into the wild, you cannot control it. You can't mathematically guarantee that a malicious actor, like a hostile nation state or a hacker, won't capture that virus, mutate it, and attack healthy cells.
Right. A vulnerability created for the government is a vulnerability hackers can and will exploit. If you build a structural weakness to catch drug traffickers, foreign intelligence agencies will use that same weakness to compromise your power grid.
Exactly. This systemic risk is exactly why this is a global struggle. The legal notes map this out across multiple jurisdictions. The US, the UK, Australia, the EU, China, Russia. They are all fighting this battle.
Right. Didn't the UK have a massive flashpoint with their online safety bill recently?
Oh, absolutely. The rhetoric was intense, heavily focused on child protection. And it really looked like they were going to force platforms to scan encrypted messages before they were sent.
Client-side scanning.
Right, which is just moving the back door to the edge of the network. But here is the crucial reality of the global landscape right now. Despite all this aggressive posturing, no major democracy has actually imposed a complete blanket ban on E2EE.
Which is fascinating. If the political will is there, what's stopping them?
It comes down to the legal test. Any restriction on a fundamental right has to satisfy necessity, reasonableness, and proportionality.
And banning a critical security infrastructure used by billions of innocent users fails that proportionality test spectacularly.
It really does. You can't use a sledgehammer to swat a fly if the sledgehammer destroys the foundation of your house. Furthermore, a ban is practically unenforceable against the very people it targets.
Oh, because sophisticated criminals would just download different unregulated software.
Exactly. The math of encryption is open source. If a democracy outlaws mainstream encrypted apps from official app stores, organized crime syndicates aren't going to just start texting in plain English.
They'll just compile open source protocols, host them on a server somewhere, and continue seamlessly.
While everyday citizens are left completely vulnerable to cybercrime.
So, if breaking the math of encryption breaks the internet, violates constitutions, and fails to stop criminals, how are countries actually moving forward?
They are abandoning the idea of breaking the encryption math. We are seeing a massive strategic pivot. Governments are now investing heavily in digital forensics.
Okay, what does that mean in practice?
It means metadata analysis, device hacking, AI, and international cooperation. If you can't intercept the message while it travels, you wait until it lands. Device-level hacking, like exploiting a vulnerability in your phone's operating system to read the message after it has been decrypted on your screen.
Wait, if they are pivoting to metadata and AI to figure out what you're doing anyway, aren't they basically just sidestepping the encryption? I mean, does the lockbox even matter if they can learn everything by looking at the outside of it?
That is the million-dollar question. Because people hear metadata and think it's harmless. Just the envelope, not the letter, but that is obsolete.
Because it's the data about your data.
Yes. The time a message was sent, the size of the payload, your IP address, the frequency of communication, your precise geolocation. And with AI pattern recognition, law enforcement doesn't need to read the contents of your messages to know what you're doing.
Right. The AI models can correlate those events with terrifying accuracy.
Exactly. This is why the debate over banning end-to-end encryption is increasingly viewed as a distraction. The state is already building an entirely new apparatus of surveillance based on metadata.
So as we synthesize this entire deep dive, what is the core theme here?
The core theme is that this debate isn't actually about technology at all. It is about the fundamental social contract between citizens and the state. It's about how modern democracies balance liberty with security and innovation with accountability.
It's a constitutional tightrope walk. And I want to remind everyone listening, every time your phone updates a messaging app, this invisible battle is happening right in your pocket. The code itself is defining the boundaries of your autonomy.
It's a constant friction, but that friction ensures any expansion of state power is met with resistance.
Before we sign off, I want to leave you, the listener, with a final provocative thought derived from the source material. Something for you to mull over on your own.
Oh, this is a good one.
Right. So, we established that criminals can easily switch to alternative software, and that law enforcement is relying heavily on metadata now. So think about this. If a government were to successfully ban encryption on mainstream apps like WhatsApp, and all the bad actors immediately migrated to obscure, unregulated apps on the dark web,
Which they would.
wouldn't the government ironically lose access to the metadata they currently rely on? By trying to ban the locked boxes, could a government actually end up making itself completely blind?
It is a phenomenal paradox. In their pursuit of total visibility, they risk engineering their own darkness.
Something to think about next time you hit send. Thank you so much for joining us on this deep dive into the Ambat Legal Insight sources. We'll see you next time.
Subscribe to Ambat Legal Insight and stay legally informed with clear, practical, and reliable breakdowns of the law. Follow our channel and activate the bell icon so you never miss important legal updates, case analyses, and expert insights that matter to every citizen. Support our mission of spreading legal awareness by liking, sharing, and commenting, because your one action can help thousands become more legally empowered. Join the ALI community today across YouTube, podcast, and social platforms and take a step toward understanding your rights, your laws, and your justice. Ambat Legal Insight, because law is for everyone.